Welcome everyone, and thank you for joining us for today's webinar. We hope that you are safe and healthy, and we appreciate you taking the time to be here with us today. You'll be able to participate in a live Q&A at the end of this webinar. So if you have any questions at all during the presentation, please don't hesitate to type them into the Q&A area of your Zoom control panel. And if you miss anything, please don't worry. We will be sending a link to the recorded session of this recording when it's available. Throughout the webinar, you'll be seeing poll questions related to the webinar topic. These poll questions are not live. However, you can feel free to take the time to write down your answer and compare it to the answer that Sam, our presenter, will give us after a discussion of the question. Please take your time with these. You're welcome to pause the recording when it comes to you later on. My name is Jennifer Sterling, and I'm an instructional designer with the CE Shop, the leading provider of online real estate education. Today, we are reviewing land use controls as they relate to the national portion of your licensing exam with Dr. Sam Martin from North Carolina. Sam comes to us with a tremendous amount of experience in real estate education and was recognized by the Association of Illinois Real Estate Educators in 2014. Sam is the owner of samthetutor.com. Now, without further ado, I'll turn it over to Sam to get us started.
Well, thank you very much. My name is Sam Martin. Please, everybody call me Dr. Sam. Today's topic is about land use controls. And as you can see on the slide in front of us, land use controls and regulations don't really make up a whole lot of your state license exam, and probably not a whole lot of your final exam from the CE Shop. But as I've always said, you can't give questions back to the state. So you'd like to get all the questions correct that you possibly can. And in real life, this is an incredibly important topic. You have to understand land use control, such as zoning, for example, so that you can better represent your clients and customers. They expect you to have some basic answers for them. So while you can't practice law, you can't give your clients and customers legal advice, but they expect brokerage related advice from you once you are a licensee. And you might have a client who is counting on you to do the research to find out what the zoning of a particular property is and what sorts of things might be allowed. So let's say for a parcel of vacant land that they're searching for. So land use controls make up basically government rights in the land, government control, and private controls. The government limitations on everyone's ownership in real estate, the acronym that is the handiest, I think, to use is PEAT. That's police power, eminent domain, taxation, and escheat. Well, police power is the main topic for today. The power of the government to tell you what you can do with your land. Eminent domain, which is another really important topic. Eminent domain is the power of the government to take your land for the greater good of the public in exchange for fair compensation. Taxation, everyone's favorite topic, is the power of the government to tax your ownership for the greater good again. And escheat, that is the power of the government to take your property if you die without a will and they can't find any heirs. But as I said today we're talking about police power. Police power consists of zoning and master plans, building codes, the regulation of special land types like flood zones and wetlands, the regulation of environmental hazards, like the types of hazards, the abatement of hazards, restrictions on contaminated properties. Each of these topics is a degree in a college. Each of these topics is a career that someone has devoted to that topic. So these are potentially very, very, very heavy, kind of heavy duty types of topics. But for us, of course, we don't really need to get that deep into these topics. We just need to kind of skim the surface and learn enough so that we can pass exams. So now let's see, here we go. A question: which of the following is least likely to be regulated by zoning ordinance? And I hate questions with a format like this, but we felt it important to put one in this slideshow, because on state exams, they often are going to say, which is least likely, which is not, which of the following is not something. So you have to be very careful when you read the actual problem itself. Would it be building facades, building placement on the lot, building codes, or building use? And that answer is building codes. Now, zoning and building codes are examples of police power. That's, I think, what gets a little confusing. Building codes is the power of the government to tell you how to build the improvement. Studs and joists, are they 16 inches apart? What types of materials must walls be made out of? Things of that nature. Zoning gets into more details about where the building can be placed on the lot. That would be building placement. Cary, North Carolina, is the home of aesthetic zoning. That would be A, building facades. Building use, again, could be a zoning type of issue. So building codes, even though it is a police power, is not zoning per se. And let's see. With respect to zoning ordinances, another question, the government is responsible not to interfere with private ownership rights. Zoning ordinances address the regulation of construction details. Most ordinances are adopted at the state government level, or some ordinances may simply address the aesthetics in a community. I gave you the answer for the last question when I gave you that explanation, which is an important tool, because when you're taking a test, sometimes they give you a hint in a previous question, some information that might help you answer the current question. So in zoning ordinances, the zoning can even get so busybody, if you will, that they can tell you the look and feel of buildings to make them conform throughout the community. Conformity is an appraisal principle that says that if you conform, then you enhance property values in a community. And land use controls and police powers also can deal with environmental hazards. Now, for my money, environmental hazards often are controlled at the federal and the state level. So you might have the EPA, Environmental Protection Agency, but also then you could also have the state EPA, like the Illinois EPA, for example. However, local communities, which very often are the ones that regulate their own zoning, say a town, a village, a city, a county, often those levels of government will have zoning and other police powers. Well, they also can regulate locally environmental hazards such as radon, mold, asbestos, formaldehyde, lead, and brownfields. Actually, a brownfield is a, A brownfield is a heavily contaminated site that has been cleaned up enough so that the community feels it can be used again, probably not for residential purposes, probably for industrial or commercial uses. An interesting note, if a property is going to be cleaned up all the way so that it can be used for residential uses, then they call it a green field. But to create a green field out of a heavily contaminated site is a much more extensive process and a much more expensive process. And of course, underground storage tanks. There are whole laws related to underground storage tanks. So, lead poisoning. Lead. My first question is, why do they call what do they call plumbers plumbers? Where does that word plumber come from? Plumber? Because plumbers used to use lead pipes. Who handles lead pipes? Plumbers. But why plumber? Well, the chemical element lead, the symbol is Pb, plumbum. Lead is plumbum in Latin. So who handles plumbum? Plumbers. And lead has been used in construction for years and years and years. It's a heavy metal, very soft. That's why plumbers liked using it, because it was very malleable. And also, unfortunately, put in paint, a lead pipe, the solder that holds lead together. And it's really quite tragic over the long haul, because, let's take a look at this. Who's most likely to be harmed by lead poisoning? I think many of us will probably already have a clue about the answer to this. That would be children, typically under the age of 5. One of the major sources of lead poisoning is children eating lead-based paint, LBP, lead-based paint. And lead levels escalate in their bloodstream. Lead gets deposited everywhere, all throughout their bodies. And without going into all of the horrible details, the bottom line is it is such a health disaster. They passed the Lead-Based Paint Hazard Reduction Act to try to stop the usage of lead-based paint. 1978 is the very highly testable year when they stopped manufacturing lead-based paint for residential uses. That's not when the paint companies had to stop selling it, but that's when they had to stop making it. So children are the primary victims of lead poisoning, especially from lead-based paint. Which of the following environmental hazards is most likely to be recognized as a result of a musty smell? That's an interesting one. I'm wondering, would asbestos have a musty smell? I don't think so. It's odorless. Lead? No one's ever told me that lead had a musty smell. You know why lead is hazardous? Going back 1 second to that other slide, it's sweet. When lead is put in paint, it makes the paint taste sweet. And of course, children are suckers for anything that tastes sweet. Well, so am I. I'm a sucker for things that taste sweet too. Radon, by definition, is odorless and colorless. It's radioactive, but it doesn't smell musty. Process of elimination, a biological hazard, that is mold, that might smell musty. Automatic shutoffs mitigate risks associated with, let's read this for a second here. Lead poisoning. Lead poisoning, probably from lead-based paint, don't think I'd need a shutoff for that. Asbestos, no, don't think so. That's in floor tile, ceiling tile, plaster walls, stucco walls. It's roofing material. So I never heard of a shutoff associated with that. Radon, it's odorless, colorless, and just is in the environment. It's all over the place. Again, process of elimination, I'm thinking underground storage tanks. And so if you have a risk of an overflow of some sort, a shutoff is a very, very good thing to have. Which of the following is most likely to be remediated through encapsulation? Well, asbestos, that exists, well, in many, many different materials. Formaldehyde, that's again, a gas, formaldehyde gas. Mold is a biological material that grows in various parts of a house. And there's that radon again, that odorless, colorless, radioactive stuff that is a decay product of uranium in the soil. So what is it that we're trying to surround in order to protect ourselves from it? And that would be asbestos. Asbestos, let's say, for example, asbestos is in, a wall. It was put in plaster many, many years ago. Well, don't disturb the wall. Don't rip it up and just leave the asbestos alone. Not a problem unless the asbestos is friable, F-R-I-A-B-L-E. If it is friable, that means you can take it between two fingers with normal pressure and you can crumble it and it goes airborne. Asbestos mineral fibers are ultralight and they can remain in the air for weeks before they settle. In the meantime, you inhale them. There is no safe level of exposure to asbestos, and your asbestos exposure accumulates and accumulates, and it's an insult to your lungs and can cause all sorts of horrific diseases. Well, even if you have asbestos pipe wrap on an old hot water pipe, there are solvents you can buy and paint that pipe wrap to capture the asbestos fibers, to prevent them from spreading all over the place. You're encapsulating the asbestos. Okay, until you have to disturb the material. Then the asbestos goes free again. Long-term solution, which is also the more expensive solution, is abatement. Just remove the asbestos with the licensed professionals that you need in order to remove asbestos. And of course, we have a boatload of laws related to environmental issues. We've got CERCLA and SARA, and not mentioned today, there's another one called SAHARA. There are all kinds of environmental laws, federal, state, and local level. So CERCLA, also called the Superfund Act. Superfund deals with the most hazardous sites in the United States. And CERCLA basically says the EPA, Environmental Protection Agency, is supposed to identify these hazardous sites, and the owner or a previous owner or a tenant or a user of that site is responsible for the cleanup. And liability is the broadest type of legal liability you will ever see. Any type of liability you can imagine: strict, joint, several, retroactive. There is no defense against this. And basically, these parties have to pay. If the parties can't pay, then the government pays. What's cheaper, having a private party clean up a site or having the government clean up a site? So CERCLA also mandates investigatory boards to determine who's responsible for midnight dumping, toxic waste dumping. And CERCLA sets up the Superfund. The Superfund full of tax money to make sure there's money available to clean up these sites. I'm sorry. So CERCLA. And we've got the Clean Water Act. The Clean Water Act, actually Section 404 of the Clean Water Act mandates that the Army Corps of Engineers regulate public waterways and wetlands. Wetland regulation is least likely to include discharge of dredge or fill, structures that may be built, protection of wildlife, style of building facades. And again, we're looking at least likely to include, well, process of elimination. Just even if I don't know what the Clean Water Act is, discharge of dredge or fill, that sounds like something it would have something to do with. Structures that can be built on a public waterway, yeah. Protection of wildlife, it sounds like they would be all over that topic. Style of building facades sounds familiar. From a previous question, I think we called that aesthetic zoning. So I'm going with D as our answer for the thing that is least likely to be under wetland regulation. And what is the purpose of a condemnation hearing? Well, condemnation is the process where the government is trying to figure out what use a property should be and if the public's interest might be better served by some other use. So to determine if usage and the value of the property are fair, that is condemnation. So eminent domain, that's part of Pete, you'll remember. Police power, eminent domain, taxation, and as cheat. The right of the government to take your property is eminent domain. So they go to court and they prove to a judge that the public's rights and interests are better served by some other use. We need to have a highway here, not a house. The government gets permission from the court, and sure enough, they are granted the eminent domain action. They go to court, and there is a condemnation hearing. And so the right of the government is eminent domain. The process is called condemnation. The legal concept allowing the government to take is called taking. I couldn't even make that up if I tried. Who else would call the right to take taking? Oh, well. Uh-oh, it's a long question. The county offers to purchase a private owner's property in order to build a much-needed highway bypass. Which of the following statements is true about the offer? The owner should accept the offer because a condemnation will result in the property being taken with no compensation. The owner should refuse the offer because condemnation is likely to result in a higher price. The owner must accept the county's offer provided the bypass is needed. The owner may counter the county's, sorry about that, let me start over. The owner may counter the county's offer if they want more for the property. This sounds interesting. The government's offer is not written in stone, and it's not something that you have to accept on its face. So the county made an offer. Now the owner's looking at the offer and they've got time. They can consult experts if they wish to, and they can counter the offer. If they wanted to, they could actually take the county to court and try to get more money that way. It's unlikely they'll be able to defeat the eminent domain action itself. But there's every likelihood that they'll be able to counter the county's offer, and they will probably be able to get a little more money. What property-related tax may cease to be an obligation after 10 to 20 years? Would that be ad valorem, which means according to value? Is it a special assessment, transfer tax, or a recording tax? That would be a special assessment. An ad valorem tax is persistent. It's according to your property's assessed value, and the government is going to be charging you again and again and again every year for that real estate tax. A transfer tax is based on the transfer of real estate, and many different government entities will have some kind of transfer tax or other. Recording tax is just some other monkey business tax that some communities will inflict on you to record documents or record a transfer, maybe. But a special assessment, they rip up your street. They're improving the street, the sidewalks, the curbs, the gutters, the sewer line, water line, street lights, public improvements. And so a perfectly framed answer here would be public special assessment, to differentiate that from a private special assessment, like in a condominium project, for example. But a public special assessment, usually you will pay once, maybe, if it's not too terribly much. Maybe they'll give you an option to pay over time. You might be able to get a loan from a bank to pay over time the special assessment, and then done. Once you've finished paying it, that particular special assessment is gone. So under real estate taxation, a special assessment, usually you're assessed essentially a tax. This is a kind of tax. And you're assessed for the benefits the work, the public work, is providing for you. Usually it's paid off over a period of time and then done. Ad valorem is based on value, based on assessed value, and it's assessed value times a tax rate, and that equals your annual ad valorem real estate tax bill. As cheat, you die. I hate examples that start with you dying. I just hate that. I hate it when that happens. You died intestate, a fancy way to say, excuse me, that you died without a will. And not only did you die without a will, but you have no known heirs. Well, where's your stuff gonna go? The probate court, they're gonna be looking around, trying to figure out where is your property going to go. Well, they can't find anyone, so therefore the government decides to keep it. You have to check your jurisdiction, your state, for example, your county, where their rules say these things have to go. For example, in Illinois, real property is cheats one place, like the county. Personal property is cheats to the state. In North Carolina, everything goes to the state of North Carolina. And so you have to double check in your circumstances where different types of properties might be going. And my advice, I can't give legal advice, but I can give common sense advice. If you don't like the idea that the government's going to get your stuff, maybe it's time possibly to consult an attorney and maybe draw up a will so you avoid that kind of eventuality. In which of the following cases is land likely to escheat? A joint tenant dies intestate and no heirs under the law of descent and distribution can be found. It sounds like it might have some promise, but maybe not. The whole joint tenant thing kind of troubling. A property owner fails to pay real estate taxes and the statutory period of redemption expires. A tenant in common dies intestate. The plot thickens. And no heirs under the law of descent and distribution can be found. The land is needed to build a public school and the government is unable to negotiate a purchase. Aha. It's the ownership. That's what messes everybody up. If it's a joint tenant with the right of survivorship, when the joint tenant croaks, the joint tenant's interest in that real estate goes to the surviving joint tenant, not to the government. But if it's a tenancy in common, when the tenant in common dies and there is no will and there are no known heirs, there is no right of survivorship. So the surviving tenant in common doesn't have a claim on the real estate. So this tenant in common's share of the real estate is going to go to the government under escheat. And actually, it is known as escheatment. The property is claimed by the government in an escheatment. Now, private controls. Deed conditions. It's one of my favorite topics, deed conditions. Covenants, conditions, and restrictions, otherwise known as CC&Rs. And homeowners association regulations. Oops, let me back up here and I'll give you the nitty gritty about these three topics. Hang on just a moment, please. This is just water, nothing else. It's only water, just to clarify, in case you were wondering. So a deed condition is literally a condition placed on the deed. I am transferring title to the buyer. I'm the grantor. The buyer is the grantee. The buyer wants the title. To get the title, they must legally accept my deed. If they accept my deed, they have to accept the condition. Why would I put a condition on the deed? Any one of a million reasons. It could be philosophical, it could be legal, it could be religious, it could be almost anything. One thing, it has to be legal. So in other words, I can't put a condition in the deed that says that you must never sell this property to purple people. That would be illegal. That's a violation of civil rights and fair housing. But practically anything else would be acceptable. I could put a condition in the deed that says that you must never tear down any of the oak trees on the property. I like oak trees. I like my oak trees. I want them to be preserved. Do you agree? Great. Accept the deed with the condition in it. If you don't quite agree, well, this has to be discussed when we're negotiating the contract. I can't spring this on the buyer at the last minute at the closing. Like, whoops, surprise, here's a condition. So while we're negotiating the price, we'll also be talking about conditions that might be on the deed. And can a condition on the deed have an impact on the ultimate sales price that is negotiated? And absolutely, it positively can have a tremendous impact on the sales price and other terms of the contract. So a deed condition is a private thing. It's not zoning, which is public. It's not eminent domain. It's private from party to party, from grantor to grantee. Do you accept this condition? A deed condition also runs with the land. So in other words, I sell my house to party A, party A sells it to party B, party B sells it to party C. C is now the owner. C also must abide by that condition. And if C violates the condition, the title comes back to me. That's called a reversion, where title goes back where it started from. So the title would revert to the party who created the condition in the first place. If I'm already dead, then that property will revert back to my estate. One or the other, either I or my estate are going to be getting the title back if somebody violates the condition. Covenants, conditions, and restrictions, a similar but a little bit different type of example. A CC and R, I'm an appraiser as well, but I have appraised many, many houses that were in HOAs, which we'll be talking about in just a minute. But I've appraised many houses that were in a homeowners association and a planned unit development, and they had CC&Rs for conformity, for uniformity, to help maximize property values. Well, a possible condition in a CC&R. Well, let me describe this. This is an honest to goodness true example. This is kind of an upscale community in Illinois where I had done an appraisal. It said all mailboxes had to be made of white brick, and the top of the mailbox was a double brick white arch of bricks, and the mailbox would go inside that arch. There'd be a brass plaque on the mailbox with the house number on it. That was just one of the CC&Rs. All driveways had to be paver brick, which is a very upscale type of brick. The house had to be at least 90% masonry on the outside. Roofs had to be, they would prefer clay tile, but they'd let you get away with cedar shake, maybe. Gutters and downspouts, copper. And so what type of subdivision is this? If you buy in that subdivision, you are agreeing to the CC&Rs. It's recorded. You get a copy of it when you buy the place. So the statement they're making, the developer created these CC&Rs, and subsequent homeowners all had to agree to it. The statement is, we're trying to keep Dr. Sam out of the subdivision. So this is not the kind of place where I can plunk down some money and buy one of those multi-million-dollar homes. Unfortunately, not happening anytime soon. And then homeowners association regulations, and that could be tied in directly with CC&Rs. So homeowners association regulations could be in a development, like a PUD, a planned unit development, could be in a condominium project. You might have heard of a homeowners association in, say, a high-rise condo building, and they can be so restrictive as to say They can tell you the color of your window treatments. All window treatments must be white or off-white. Everybody's window treatments are white, except that one guy whose window treatments are purple, standing out like a sore thumb. HOA will never tolerate it. They will very politely ask that person to change their window treatments, the drapes, the blinds, things like that. And there are a raft of association regulations that everybody has to comply with. And let's see now. I do believe that's all I've got for private controls. On your state exam, there will be some experimental questions. Who are they experimenting on? That would be you. They want to see if those questions are fair. Do too many people get them wrong? Do too many people get them right? There are around 5 to 10 of those types of questions on your state exam. They're not graded, and typically the timer stops when you're on one of those experimental questions. The timer stops because it's not fair to burn up your test time while you're a guinea pig for PSI, Procore, or Pearson VUE, or whoever the testing service is. So please, please, please check your candidate handbook or candidate guide. You should be able to get that from CE Shop, or go right to the source. Go to the website of the entity that is administering your test. Your state license agency, they might have a candidate guide. It'll tell you the total questions, a breakdown by subject, and what the passing scores are for your test. Let's see. And are there any other questions?
Wonderful. Thank you so much, Dr. Sam. We very much appreciate you being here with us today for this recorded presentation. Your expertise, your willingness to share it with our student community is very, very much appreciated. And at this time, we will be moving on to the live portion with any questions from our students. Thank you so much.